So I'll bring it now back to the committee for questions of the panel. And there are a lot of questions raised by the presentations, and I very, very much appreciate that you coming in. And I know, looking through the Hosanna Tabor case, there are a lot of, the court was only willing to go so far with it. I think that's fairly clear, and said that it's going to look kind of on a case-by-case basis. But I don't see in the court or in that opinion or other opinions any real definition of what a minister is. And I think it's in some churches it might be more clear, in others less clear. And one of my concerns is that by putting in a contract that you're either now considered a minister or putting language to make someone a minister, even when they don't realize that they're performing that function or don't have any intention of performing that function because they're maybe not of that religion or they're seeing themselves as lay. How do we address what is a minister or isn't? Is there a definition that helps focus what we're talking about? Because the Hosanna Tabor is the law of the land. I understand that long-standing protection of religion from governmental intrusion. That is, Sarah saying, that is not something we're going to step into. But how far does that go? And I think part of understanding how far the decision goes is understanding what it is we're talking about. And I'm not clear how any one organization actually defines its ministers. And does anybody have a...
Yeah, if I could start, please.
Yeah.
First of all, you're not looking to see whether somebody is a minister. You're looking to see whether they qualify for the ministerial exception.
Correct. And understanding that in different organizations it may not be a minister, and I'm using that term as the exception does, even though that's an inaccurate term for any number of the religions that might be out there. They may not have an actual minister. But somebody who's going to fall into, how do we define that position that is going to be able to be taken advantage of through the ministerial exception?
I think the way that the court looks at it is somebody that has as part of their duties the carrying of the message of the particular religion.
Okay. Well, and then, Mr. Berman, something that you said history or geology or courses that have no faith-based perspective in there. And
well, I've said that those are courses that most of us who went to public school wouldn't think would be faith-based, but faith-based schools bring faith into those kinds of classes.
Okay, that's actually not what you said, and because I wrote that down and I was going to the way you had said it I disagree with, because in reading the Bible, for example, I think clearly history and geology do have very significant religious implications to them, which is where my question is, and it's sort of back to this notion of who falls under the ministerial exception, because a literal reading of the Bible translate forward now towards courses at a modern high school, even a religious high school, where the classes are A to F compliant, UC compliant, that you're educating a student to be able to go into UCs, there's going to be a difference there. And a teacher, I think a good teacher would facilitate the debate, facilitate the conversation, ideally strengthening the faith of the student, but being able to draw those differences. And so isn't then that teacher potentially teaching something that is cutting edge, that is sort of pushing what strict religious doctrine might otherwise say?
You're asking the wrong person, because I only went to public school. But I think.
Well, but I mean, we're looking at sort of legal distinctions here.
The legal distinction would be, even if you offer up both sides of the debate, that you are advocating one side of the debate. So there are certain religions that believe that the earth was created relatively recently,
correct,
as opposed to billions of years ago. And teachers that are teaching the appropriate coursework would say that, there are some people that believe that the earth is 5 billion years old, but we don't believe that. And here's why. So that would be a history of the earth 101 class They would say what the other side says, but they would come to a conclusion that no, that's not correct.
Well, help me out then, somebody who's been in the schools, because how does that meet the state's, UC's 8F requirement if you're not?
Maybe I can help you out.
Yeah.
When the schools are doing transcripts for the UCs, some religion classes count and some don't.
And I understand that. And so I'm really focused on the classes that would count.
For the classes that count, they have to submit what they're teaching in that class to UC for approval. Mm-hmm. That's the accreditation process.
Right, and that's
my
any school in
understanding is, I'm not a counselor, but I was on the counseling floor, so I heard a lot about this. My understanding is that in order to qualify for that, this piece of advocating a religion cannot be an element of the class. Whether some teachers kind of under the radar do that, I don't know. I can tell you at our school that the religion teachers took that seriously. And so the upper division classes, whether it was social justice or whether it was comparative religions, and there were any number of other ones, they approached as creating an understanding of religion in their students and of different religions, but not as trying to inculcate any particular religion for the students. Am I missing your question?
No, I think a little bit. I understand in a religious school that is a religious teacher that is teaching a religious perspective. That's a lot of what the school is about. And even in what Mr. Berman read, a lot of schools are very clearly proselytizing, trying to bring into the fold their students. But yet, these are schools that have courses that are accredited to go on to the UC. And so I'm assuming that they have to be done in a particular way. As I read the morality clause, a teacher then who is teaching a class that would then be accredited to go to the UC might actually be violating the clauses as I've read them. And so which I can't imagine is the intent, because that undoes the accreditation. And if you can take the accreditation away from a popular, significant set of schools in California, I'm struggling with that dichotomy there. And so maybe...
Mr. Chairman, to be quite honest, I'm not sure I follow completely the question, but okay. I'm going to try to answer it anyway, which is that, in my experience, religious schools do run up against teaching secular issues that aren't consistent necessarily with their own religious beliefs. And I'll give you a quick example. I visited a school, it was evangelical Christian. They were showing me their science department, and I asked them how they teach evolution. There was a dead silence in the room. It was very uncomfortable, for me anyway. And then they talked about their beliefs and how they think it's important for their students to know about evolution and to understand it and something that they're going to encounter. And I really feel that, and by the way, I've had similar discussions at Islamic schools over math, and that is viewed as an Islamic subject. And in my mind, those kinds of decisions are best left to the religious leaders of those communities, and not somebody else to dictate what is religious and what is not, and what conflicts with their religion.
Well, yeah, but I'm not talking about dictating. I'm talking about a school that wants to be accredited by University of California. And University of California says, here's our requirements.
Right.
The school can choose to be accredited, not be accredited. Right? And I think a lot of schools that want to provide a higher level service to their students would want that accreditation.
Correct.
They don't have to. But if they do, that's now a state governmental statement, because it's a University of California requirement that says this is what that requirement is. And so in that classroom, there are discussions about topics, and they're being taught in a way that are fundamentally different than what the religion might want to be teaching their students. Am I correct?
Well, I'm not sure.
Just by your description.
I think that, just very quick, I can see Professor Grip wants to chime in. So let me just say very quickly,
Sure.
If I understand you correctly, it would be problematic for a religious school to teach a subject in a way that conflicts with its own religious beliefs. And I don't think that's the case.
Well, but just by teaching, for example, evolution in a school that is very strictly following the tenets of Christianity, in order for them to get accredited, they would have to offer a class that legitimately talks about evolution. And my concern in all of this, which is fine, I mean, the school gets to make that choice, parents get to decide whether or not they're going to put their children in there. But as I read the morality clauses that were put into these courses or into these teachers' contracts, just the teaching of something that's outside the tenets of the school in order to satisfy the UC requirements is arguably a violation of the morality clause. And so if that's in there and you're trying to meet the obligations of an external accreditation body like the University of California, aren't those potentially morality clauses then being arbitrarily enforced?
Mr. Chairman, let me see if this case can help answer your question. One of the cases we have post-Hosanna Tabor is from the Kentucky Supreme Court. And there was a man, Dr. Lawrence Kant, who was a Jewish rabbi and a PhD in religious studies from Yale. And he taught Hebrew Bible and other history of religion types of courses at Lexington Theological Seminary, which is a Christian seminary. And addressing your question, I think for his career there, they were probably happy to have this well-credentialed academic rabbi, PhD, very distinguished professor. But then the school ran into financial difficulties, and they fired some tenured professors, and he had a breach of contract lawsuit. And so it's at that point that, it's when the lawsuit occurs that the school says, you're a minister now, right? And so the time that the morality clause becomes relevant probably isn't in the day-to-day life of the school affecting what the teacher is teaching, but where it comes in as what I call the silver bullet is all of a sudden when Dr. Lawrence Kant, with his PhD in religious studies, teaching Hebrew Bible. When he was in court, he had to fight for his life. And finally, the Kentucky Supreme Court said, when we look at what he was doing, he wasn't a minister, even though he taught in a Christian seminary. But if I had a few more facts, we keep saying Hosanna Tabor is about facts. If I had a few more facts, like a morality clause or that the school said I was leading prayers every day, then you tip away, right? But, my own view is it's hard to make a Jewish rabbi, religious studies professor, a minister, but some courts were willing to do it depending on how many facts you had. And so what the contracts do is add facts for the lawsuit. And I respectfully suggest if we spend all the time on what you're getting in for the details of the lawsuit, you might miss your point to address kind of what legislation governs schools, or the types of questions that Ms. Purcell addressed. Right? It's very hard to back into what the law should be from this narrow thing called the ministerial exception.
Well, true, and that's kind of why we're, I think, exploring the breadth of what this represents. And what I think we also have to be cautious about is utilizing religious or constitutional protections using the First Amendment doctrine for arguably political purposes, and that's where I think we need to ferret a little bit more out. Mr. Ting, I'm sorry.
I was just going to let Ms. Purcell jump in.
Well, going back to where you started, I think what you're raising, if I'm understanding you, is that at some point schools and institutions affiliated with religions have to decide who they are. And if they're really religious, then there are certain things they don't get, like going out and soliciting a lot of non-Catholic Chinese students for their money, or like it might mean they don't get UC accreditation. But part of the problem is they want it all. They want all those benefits, but they also want this broad capacity to discriminate with impunity. And I think that's part of what's at stake here.
Yeah, and I think that's a little bit of the dichotomy that I'm trying to understand here, is that the protections for the religious purposes, but yet operating in a modern and complex world. And as I read sort of what's at stake, which is the morality clauses and the framework within which this is coming out, that's making the employees who may not consider themselves to be ministers, and I understand it's really more the school's decision, but kind of brought into this that gets used potentially selectively instead of consistently, given a particular outcome that's intended by the organization. And it's a delicate area because of the separation of church and state under the Constitution, but it's the kind of thing that in employment law in California, we've worked very hard to ensure that any organization is acting at a certain base level of consistency with respect to its employees. And I think some of the frustration that's coming out is that ability to apply a standard inconsistently depending on the circumstances that the organization finds itself in, as opposed to a more clear standard that's across the board. And I think that's some of the challenges.
Can I make a point? Excuse me. Go ahead. You're on the dais, so you get to go first.
Go ahead.
Okay. I don't pretend to be an expert in accreditation standards, even though I did go to the UC system. But we have clients that actually wrestle with these kinds of issues when it comes to getting government money. And we have clients that I've talked to them, and they have made conscious decisions to pass up on government money because of some of the strings that are attached to the government money and that would prohibit them from being able to practice their religion as they see and get the money. So I don't know about the UC accreditation standards, but I do know that at least my clients do anguish over this issue. They're not trying to have it all. And we've got that situation going on, now where there's an issue of federal bond funding or state bond funding. And we have a client that may have to give up $165 million because it's too religious, and is prepared to give up $165 million if it's too religious because it's going to stay religious. The other point that I'd like to make, and I think that Michael's experience is the same as mine, I've handled hundreds of cases, maybe thousands of cases in the last 45 years for all kinds of employers, including religious employers. And the number of times that the ministerial exception has come up, you could count on less than one hand. I have a case now involving a hospital chaplain. There's not going to be too much argument that that person was a minister. I had another case that was involving a school, and it was a person who was an ordained minister and was in the theology department. But other than those two cases, I can't think of any other ministerial exception case that I've handled, and if I haven't handled it, probably nobody in my firm has handled it. So this is not something that happens every day.